Imagine a world where environmental decisions are made without input from the people they most affect. Or picture a future where the consequences of our actions today are shouldered by generations to come. The Environmental Protection Agency, or EPA, stands at the intersection of these complex issues, tasked with balancing scientific expertise, democratic accountability, and the long-term well-being of our planet and its inhabitants. But how well does it achieve these goals? In this video, we will examine what is the separation of powers, how does rulemaking work, and what does it mean now that the Chevron deterrence has been overturned in 2024. The Environmental Protection Agency's work is crucial because it grapples with fundamental questions about who decides environmental standards and how we ensure fair outcomes for everyone, including future generations. The agency operates within a complex system of laws, regulations, and court decisions, all while responding to the needs of the public and the imperatives of the science. Understanding the EPA's role is vital to addressing the environment and challenges of our time. The EPA was created to consolidate fragmented environmental regulations and to establish a centralized authority for environmental protection. The agency's establishment was a response to public outcry over environmental crises like severe air pollution and toxic waste contamination. Key legislation such as the Clean Air Act, the Clean Water Act, and the Safe Drinking Water Act empower the EPA to set national standards and enforce regulations. The Environmental Protection Agency operates as part of the executive branch of the U.S. government. Based on the Constitution's separation of powers, Congress writes the laws, the judiciary resolves arguments about what the laws means, while the executive branch enforces the laws. In writing laws about environmental concerns, Congress provides broad guidance and clarity on the goals of the legislation. However, it does not have the expertise to determine the specific way in which the law will be implemented. For that, the EPA, like other federal agencies, enters a process of rulemaking. The rulemaking process, governed by the Administrative Procedure Act, mandates public participation and ensures regulations reflect scientific and community concerns. This process begins in the pre-proposal stage. Congress passes an authorizing law that is signed by the President. Then the EPA works with stakeholders, including scientific experts and industry professionals, to draft a rule. The rule is then submitted for interagency review if it impacts on the activities of other federal agencies. Stage 2 of the rulemaking process is the formal proposal stage, where the proposed rule is published in the Federal Register and a 30 to 60-day public comment period occurs. Based on feedback, the agency revises the rule that is once again subjected to interagency review. Once finalized, the rule is published in the Federal Register, but this isn't the end of the process. There are opportunities for both congressional review and judicial review, which may clarify or limit the EPA's authority. The EPA uses scientific data to develop and enforce environmental regulations, drawing on research to understand the impacts of pollutants on public health. The Clean Air Act, for example, requires the EPA to set national ambient air quality standards, which are based on scientific findings. The EPA also works with states to implement these standards, creating state implementation plans, or SIPs. The Cancer Alley of Louisiana demonstrates the severe environmental injustices faced by some communities. These areas, often near industrial facilities, experience disproportionately high rates of pollution and related health issues, highlighting the EPA's need to address environmental disparities. The EPA's authority is grounded in law, including the Clean Air Act, the Clean Water Act, and the Safe Drinking Water Act. The agency operates under the Administrative Procedure Act, which requires transparency and public engagement in its rulemaking process. The EPA also collaborates with state and local governments, promoting a cooperative approach to environmental management. To be sure, the Environmental Protection Agency has faced criticism regarding its regulatory authority and effectiveness. Some argue that the agency's regulations can hinder economic development, and the costs of compliance place an undue burden on businesses. There are also legal challenges to the EPA's regulations, with some Supreme Court rulings limiting the agency's power and undermining the Chevron deference. which previously allowed courts to defer to agency interpretations. In the 2024 ruling in Loper Bright Enterprises versus Raimondo, the United States Supreme Court ended a 40-year precedent called the Chevron Deference. The Chevron Deference was established in 1984 in the Supreme Court case Chevron USA versus the National Resources Defense Council. In 1984, the Supreme Court ruled that if a statutory language in a law was ambiguous, and again, remember that Congress writes the law, but they're not the experts on how to implement it. But if the statutory language of the law, was ambiguous and subject to reasonable interpretations, then the courts should defer the decision of enacting the law to the expert guidance of the federal agency accountable to the elected president. What that means basically is that based on the Chevron Deference established in 1984, we're looking at if we're not sure what the law actually means, we use the information from the experts from the federal agency involved with enforcing that law to come up with the explanation and the interpretation. The EPA operates at the intersection of complex forces, scientific data, legal frameworks, and public needs. As new challenges emerge, such as climate change and the introduction of new pollutants, the EPA's role in balancing economic needs, environmental protection, and ethical considerations is more vital now than ever before. Ultimately, the ethical questions regarding environmental protection are not solely the responsibility of the EPA, but require broad public participation, informed debate, and a commitment to protecting the health of our communities and the long-term future of our planet. So what do you think? Join the discussion in the comments below and let us know what you think about these important questions. How do we balance the need for scientific expertise in environmental regulation and democratic accountability? What technical decisions affect millions of lives? When technical decisions affect millions of lives, who should have the final say? Experts, elected officials, or judges? Given limited resources and competing priorities, how should the EPA weigh protecting the greatest number of people against addressing the most severe environmental injustices affecting smaller, often marginalized communities? To what extent should current economic interests be sacrificed to protect environmental resources for future generations? And finally, how do we fairly distribute the costs and benefits of environmental protection across generations? Thank you, and have a great week.